Good morning to all of you. Andarki Shubhodayam. Welcome to Legal Matters by Sai Babu Sukh. Civil case. Honorable High Court of AP, Justice V. Gopal Krishna Garu, in the case of G.Manohara Reddy and another, versus K. Chandrasekhar Reddy and others. Second appeal number 1108 by 2011. On 20th June 2025, held that injunction orders cannot be granted when the gift deed is not cancelled in the past 40 years. The gift deed is continuing. When once the gift deed is continuing, the title follows or title flows. How can we give injunction against that particular person? Even in the second appeal also, same subject was discussed and it is held that the first appellate court is 100% correct. Okay, now let us go into the facts of the case. Remember, this is second appeal. Second appeal is 100 section 100 of the CPC. The second appeal is dismissed, holding that the first appellate court analyzed the evidence carefully. No doubt. Basically, you have to understand what is first appeal and second appeal. Second appeal is only if a particular thing allotted to CPC. నార్మల్గా మిగతా కోర్టులో అయితే జిల్లా కోర్టుకి వెళ్తాం, హైకోర్టుకి వెళ్తాం, సుప్రీం కోర్టుకి వెళ్తాం. బట్ వెన్ దెర్ ఇస్ అ సబ్స్టాన్షియల్ క్వశ్చన్ ఆఫ్ లా, second appeal can be filed in the High Court. Right. So better to know the facts of the case. Chandrasekhar Reddy, Manohar Reddy. Chandrasekhar Reddy అసలు దాంట్లో ఒరిజినల్ దాంట్లో ప్లెయింటిఫ్స్, మనోహర్ రెడ్డి వాళ్ళు డిఫెండెంట్స్. Chandrasekhar Reddy and the others, they filed OS number 225 by 2003 in the court of Gutti, Anantapur Jilla, requesting injunction order to be given restraining Mr. Manohar Reddy and others from interfering with the peaceful possession and enjoyment of the land or the client scheduled property. A property there is registered. Reason ఏంటంటే this property was accrued to them with the settlement deed dated 18/1/1982. 18/1/1982, 40 years back. And originally the property belongs to G. Sunkireddy and Lakshmamma. Sunkireddy, they have given, these are son-in-law అనుకుంటాను, ఇచ్చారు. But some people filed some partition, అది కూడా ఒక ఆడామే OS 24/91 prior to this itself. One Subbalakshmamma, she instituted a civil suit stating that this Sunkireddy has got only 1/3 of the property. I am also having a share in the poste. That was also dismissed. Actually, that should have acted as res judicata. మాట్లాడి మీకు కన్ఫ్యూజన్గా ఉన్నాయేమో, బట్ ఎనివే సిపిసి మళ్ళీ ఈ మధ్యన 10 రోజులు క్లాసులు ఉంటే మీకు ఈజీగా అర్థమయ్యేది. రైట్. 1991, a woman filed a case and it was dismissed. Now, these people, they have filed a case, they are requesting for the injunction order. Right. The trial court dismissed the suit. అక్కర్లేదు, అది ఇంజక్షన్ ఆర్డర్ లేదు, suit dismissed. That means it has gone in favor of Mr. Manohar Reddy. Right. Chandrasekhar Reddy filed the case and now the case is in favor or dismissed against Chandrasekhar Reddy. Then automatically these people went to the appeal court. First appeal అన్నా AS number 2/2010. First appellate court lo it was allowed. Please remember, Chandrasekhar Reddy's cause was allowed. Injunction order has to be granted. Right. So గతంలో ట్రయల్ కోర్ట్ ఏదైతే మనోహర్ రెడ్డికి ఇచ్చినటువంటి డిగ్రీ సూట్ జడ్జిమెంట్ ఉంది కదా, దట్ వాజ్ సెట్ అసైడ్ అండ్ నౌ ది మ్యాటర్ హ్యాస్ కమ్ ఇన్ ఫేవర్ ఆఫ్ మిస్టర్ చంద్రశేఖర్ రెడ్డి. రీజన్ ఏంటంటే ఫస్ట్ అప్పలేట్ కోర్టులో రీజన్ ఏంటంటే ద ప్రాపర్టీ is not, the gift deed is not at all challenged. Main problem. 1982, the gift deed was not at all challenged. No legal evidence has been adduced to say that Sunki Reddy has got only 1/3 of the share, and no steps were taken to cancel the gift deed. No rebuttable evidence placed by the defendant to show for the past 40 years. Second point, so they have adduced evidence through some that is oral evidence. So on which date and year this has problem? They spent so much of amount on they wanted some money. Of course, that is outside the court. So gift deed is not cancelled. When gift deed is not cancelled, title is with the plaintiff and the title follows possession. Plaintiff and our Chandrasekhar. So ఈ లోపల వీళ్ళు they have got the Patadar passbooks, the records were mutuated in the name of Chandrasekhar Reddy. So therefore, High Court said, First Appellate Court analyzed the facts correctly. Trial Court gave undue importance to inconsistencies or discrepancies which are not at all material. So second appeal is dismissed, of course. High Court not to sit on first appeal and factual findings errored. So I say Pondakalani చెప్పి డిసైడ్ చేశారు. ఇంపార్టెంట్ కేసుల గుత్తా వెంకటరమణ వర్సెస్ జి సిద్ధప్పనాయుడు 2022 ఇలాంటి కేసు జరిగింది. దీంట్లో మీరు గుర్తుపెట్టుకోవాల్సింది, ఇఫ్ ద సెటిల్మెంట్ డీడ్ ఈజ్ నాట్ క్యాన్సల్డ్ when you are fighting on the same gift or settlement deed, when you could not get it cancelled, when you could not make any efforts to get it cancelled, when you could not produce any evidence against the same, how you can order for so-called, how can you come to the appeal court and చెప్పి కొట్టేస్తారు. Very good judgment. Read it and enrich your legal knowledge. Thank you.